Well, good afternoon, everyone. Thank you for joining us remotely at the University of Kansas School of Law for a fall plenary lecture today with Professor Franita Tolson. The number of folks participating in today's event is significantly higher than it would have been had we limited attendance to our law faculty. In a typical year, we hold small faculty workshops with professors from other law schools who travel here to engage with our faculty about their scholarship, and our faculty travel to other schools to do the same. We usually host these workshops in our faculty lounge and limit attendance. But in the unique circumstances of the pandemic, with travel restrictions in place, we decided instead to open up this particular event more broadly to take advantage of the benefits of the remote environment, and I'm really pleased that we have done that. If you think that we selected by happenstance an election law expert to speak during the week of the presidential elections, then you underestimate us. I feel lucky that we were able to attract such an outstanding scholar on this relevant topic at this particular time. I want to thank Professor Tolson for taking time out of her very busy schedule to be with us. And as much as I would like to introduce her, I'm going to turn that honor over to our Associate Dean for Faculty, Uma Autka, who, along with our Faculty Speakers Committee, did all of the logistics surrounding today's event. So thanks again to all of you for being here, and I will turn the program over to Professor Autka.
Thank you so much, Dean Mazza. And it is indeed a great pleasure to be able to introduce Franita Tolson. Before I do, I want to acknowledge the entire Workshops and Lectureships Committee for their work on this and other presentations this academic year. The committee includes Professors Lua Ewell, Kyle Velty, Najarian Peters, and Alex Platt, all of whom helped create this opportunity to gather remotely for a plenary fall lecture at KU Law. Also, great thanks to Rebecca Clayton and Margaret Hare for their work, as well as Ashley Gould for their help in promoting the event and making it possible through this webinar format. With elections on everyone's mind this fall, and especially this week, we are pleased to be able to share this opportunity to hear from Franita Tolson, Professor of Law and Vice Dean for Faculty and Academic Affairs at the University of Southern California Gould School of Law. Following this introduction, Professor Tolson will share her work, and then we will have some time for questions. So please feel free at any time to submit questions via the Zoom Q&A feature, and I will be happy to share as many as I can with her for some discussion before we wrap up at 5. Professor Tolson is a prolific scholar in the areas of election law, constitutional law, and legal history. She has written on a wide range of topics, including the Elections Clause, the Voting Rights Act of 1965, the 14th and 15th Amendments, political parties, and more. Her most recent articles include an article published in the Boston University Law Review entitled "The Spectrum of Congressional Authority Over Elections," and another article in the William and Mary Law Review entitled "Election Law, Federalism, and the Limits of the Anti-Discrimination Framework." Next year, Cambridge University Press is publishing her book entitled "In Congress We Trust: Enforcing Voting Rights from the Founding to the Jim Crow Era." And as if that hasn't kept her busy enough, she is also contributing book chapters to 3 forthcoming volumes, including Research Handbook on Law and Race in the US, Research Handbook on the Politics of Constitutional Law, Oxford Handbook of American Election Law, just an incredible body of scholarly work. But in addition to her in-depth legal scholarship, Professor Tolson has also expanded the reach of her work and expertise in the public sphere. She has testified before the House Judiciary Committee regarding the reauthorization of the Voting Rights Act, and she has written for or appeared as a commentator for various mass media outlets, including the New York Times, Reuters, CNN, Bloomberg Law, and she even hosts her own election-themed podcast with an academic colleague at Ohio State University Law School called Free and Fair with Franita and fully. So clearly her work is wide-ranging and in many, many modes. Prior to joining USC, Professor Tolson was the Betty T. Ferguson Professor of Voting Rights at Florida State University College of Law. And in the upcoming spring, 2021, she will be a visiting professor of law at the University of Chicago Law School, of which she herself is a graduate. Amazing as it may seem, I could go on, but instead I'll ask you now to please join me as I welcome Professor Franita Tolson to present her work, The Inevitability of American Democracy. Welcome, Professor Tolson.
Thank you so much, Professor Alka, which you failed to mention that we were colleagues at Florida State and that this is a very welcome reunion. So it's so good to see you. Before I get started, I want to invite everyone to close your browsers. Nevada, Pennsylvania, Arizona, and Georgia will not be called in the next hour, so you can listen to me. Okay. So in this moment, I just really wanted to use this talk as an opportunity to put everything that's happening now in historical perspective, because I really think that people look at this moment and they look at some of the things that are happening with the efforts to make voting more difficult for voters, and they assume that, you know, it's something that is of relatively recent vintage, even if they think about how bad things used to be, you know, half a century ago, they still don't take the long view. And I think it's really important to have that perspective. So I want to spend the bulk of my talk trying to do just that thing. Because I think American democracy really stands at a moment of reckoning, right? We are at a very important point in our history. And it really will dictate sort of how our next move as we try to evolve towards a more perfect version of we the people. But it's important to understand that, you know, while the racial and economic fault lines in this country disproportionately impact people of color, we are nonetheless contending with a number of situations that will shape the life experience of all Americans to come. So it's not just about Black and brown people. It's not just about people of color in this country. These are things that affect everybody. So namely, the racially disparate impacts of the COVID-19 global pandemic, the recent deaths of a number of African-American individuals at the hands of police officers in cities across the country, the global protests in response to systemic and institutionalized racism, and importantly, you know, all of these things are important, but for this moment, partisan efforts to disenfranchise people of color ahead of a heavily contested election year, right? Which has now turned into a presidential election that will be decided by razor-thin margins in a handful of states. So all of these things collectively, right? The assault on Black and brown lives, COVID-19, and the fact that we are, the whole country has essentially become a hotspot, the fact that it's not easy to vote in this country, all of these things might indicate that America is on a precipice. But we can't ignore, and we being everyone broadly defined, cannot disregard these things just because they disproportionately affect some communities and not all, right? Because in essence, some constituencies, especially those that are of privilege, reject this idea that we are at a crossroads, right? They think that everything is going fine, that America is fine. And part of this is rooted in American exceptionalism, right? And this American exceptionalism is at odds with our history. In fact, American democracy has always been an aspirational project. It requires work to survive. It is not, contrary to popular belief, a God-given right that will persist despite the failure of our government institutions to protect all citizens, despite the entrenchment of political minorities, and despite the widespread disenfranchisement of otherwise eligible voters. America is not necessarily guaranteed to endure. The attack on voting rights stands as one of the most obvious indicators of the failure of our democracy. A lot of this has to do from the COVID-19 voting rights litigation, which has taken place over the last few months since March, essentially, since the first lockdown. Some of this litigation worked its way up to the Supreme Court. And as we could see from how that litigation unfolded, it really is a continuation of the project began by cases such as Shelby County versus Holder and Rucho versus Common Cause, both of which place the onus on individual voters to overcome needless barriers that states erect to make it more difficult to cast a ballot. Both Shelby County, which invalidated a key provision of the Voting Rights Act of 1965, and Rucho, which found partisan gerrymandering claims to be political questions unresolvable by the courts, make it difficult for the federal government, states, individuals, anyone who cares about democracy because it's hard to vote in some states, but not all, right? But it has become very difficult to police anti-democratic efforts, and especially when these efforts minimize the voting power of racial and political minorities. So the court in recent months and sort of resolving some of these challenges that we've seen in many states over the rules governing our elections heading into this moment, the court has made it very difficult for district courts that seek to impose remedies that will make it easier for people to cast a ballot in the midst of the pandemic. They have made it very, very difficult for district courts to adopt remedies to address that. And in fact, the court's views, their opinions represent this view of voting premised almost entirely on deservedness and privilege, rather than a view of voting as a fundamental right. These decisions also assume that despite any state-imposed barriers, those who want to vote will find a way to vote. You know, if you want to vote, it does not matter if you have to wait in line for hours to do it. It doesn't matter if you have to jump through hurdles to get the required ID. It does not matter if you don't have a way to get to the polls. If you want to vote according to this court and many of the circuit courts, make it happen. And with only a few exceptions, COVID has not really softened their view on this, right? So COVID, if anything, has made the situation worse with respect to the court viewing voting as a privilege rather than a right. So, you know, implicit in this view of voting as worthy of only those who are willing to make it happen is the belief that our elections and our institutions will continue to survive, even if we exclude those who our institutions are supposed to serve, because America, after all, is inevitable. But this election is the perfect time for several reminders about our democracy, which, contrary to popular belief, is not inevitable. The first reminder is that our democracy has failed before. Right? We may have short memories and may not have been in your lifetime, but it certainly failed in many of our grandparents' lifetime, and for some of us, our parents. Second, a lot of the same voter suppression tactics that we're seeing now resembles the suppression that was the status quo during the time in which democracy was nowhere to be found. The question is, why do we keep falling into the same trap and thinking that American democracy is inevitable? Or more pointedly, why do we assume that our democracy is guaranteed to emerge intact if we are lucky and happen to land on the other side of the current challenges to the right to vote? Why do we assume that we will land on the other side as a democracy? The answer, surprisingly, is Bull Connor. Let me explain. So part of the reason why we think our democracy will endure is because we think of voter suppression very narrowly, right? So we focus on actions that affirmatively keep someone from casting a ballot rather than actions taken to make voting harder. Our narrow focus stems from the fact that voting rights have come a long way since the 1960s, which was the culmination of a century-long fight to enfranchise African Americans and other people of color who had long been disenfranchised in this country. So during the 1960s, you had new constitutional amendments, for example, outlawing the poll tax, enfranchising those who live in Washington, D.C., allowing those 18 and older to cast a ballot. There was also enforcement of long dormant constitutional provisions like the 14th Amendment, which is a source of a judicially recognized, although not textual, right? So the court just inferred it from the text. It isn't present there explicitly. So a judicially recognized right to vote. And also the 15th Amendment, which prohibits racial discrimination in voting. But the downside of this progress is that it has conditioned all of us, so scholars, courts, even everyday Americans, to look for bad actors who make their intentions to disenfranchise and impede the vote obvious and transparent. So in other words, we keep looking for Bull Connor. To answer the unspoken question, who is Bull Connor? Bull Connor was the commissioner of public safety in Birmingham, Alabama, who strongly opposed the civil rights movement. If you look at the picture in the back of this slide, it's a picture of African Americans who were trying to register to vote, being sprayed by hoses and trying to protect themselves from dogs. Bull Connor was responsible for many such attacks on African Americans trying to exercise their rights. And so, you know, the problem today is that there are some Bull Connors, but not many, right? And looking for Bull Connor ignores that voter suppression and disenfranchisement has evolved in some ways. While it is static in others, generally speaking, the law has to catch up with where we are now. Sometimes there is no Bull Connor, right? To give a modern perspective, calling on officials to stop counting lawful votes can be as pernicious as Bull Connor's water hoses, right? So sometimes when we're thinking about voter suppression and voter disenfranchisement today, there may not be a Bull Connor, but it's still wrong. In fact, if you look at things that have happened over the last decade, there have been significant setbacks in protecting the right to vote that illustrate this very fact. right? It may not be a Bull Connor. There may not be a Bull Connor, but things have happened that show that there are increasing threats to voting rights. So for the last 20 years, there has been no major federal voting rights legislation outside of updating the Voting Rights Act, despite increasing threats to the right to vote. And events in recent years have exploited the fundamental flaw of all of our voting-related amendments, their failure to grant an explicit right to vote, which has had real-world implications for who can vote and the circumstances under which they can vote. This is why I pointed out when I discussed the 14th Amendment briefly that it was a judicially recognized right and wasn't explicit in the text, because honestly, what the court giveth, the court can take away. Because there is no explicit right to vote in the constitutional text, the Supreme Court has been less willing in recent decades to effectively limit the state's ability to disenfranchise, if done so in the absence of racially discriminatory intent. In other words, the Supreme Court is also still looking for Bull Connor. Because of this focus on intent, Congress is also limited in its actions that it can take to protect the right to vote from the discrimination that the Constitution prohibits. Nowhere has this been more evident than the 2013 Supreme Court decision of Shelby County versus Holder, which I referenced earlier. That provision, as I mentioned, invalidated a portion of the Voting Rights Act, which was one of the most successful pieces of civil rights legislation in our country's history. It almost single-handedly enfranchised many African Americans across the South because of its pre-clearance provisions, which required certain jurisdictions, mostly those who had the worst records on discrimination in voting, to pre-clear any change to their election laws with the federal government before those changes could go into effect. So this provision had the impact of preventing states from using discriminatory measures to disenfranchise African Americans. But in Shelby County versus Holder, the court invalidated the coverage formula on the grounds that it was based on outdated information. So the coverage formula had not been updated since the early 1970s. If you read Shelby County versus Holder, the decision seems to effectively limit Congress to addressing only the most overt and discriminatory instances of racial discrimination in voting. In other words, where is Bull Connor? Where is the bad actor? But the failure to have an effective legal regime in place, this means that states, elected officials, political parties, private actors, they're all incentivized to exploit any loopholes, to use any available means for partisan gain because of the court's limited focus on overtly racially discriminatory intent. But suppression rarely happens that way these days. As the chart on the left shows, voter turnout among the demographic targeted by many suppression efforts has been down. Indeed, if you look between 2012 and 2016, African-American turnout dropped a full percentage point between those two elections. While some people arguably may have chosen to stay home, it is also not coincidental that it became much more difficult to cast a ballot between 2012 and 2016 because the Shelby County decision had a disproportionate impact on the demographics more likely to vote Democratic. As the chart on the right shows, there was a precipitous drop in overall turnout among Democrats in 2016. Unfortunately, we don't think of these dips in turnout, regardless of which party is affected, as a crisis. Instead, we tend to view it as a choice. People are choosing not to vote. Or alternatively, people are not willing to do what it takes to cast a ballot. But the NAACP Legal Defense Fund recently released a report that details post-Shelby threats to voting at the state and local level. So the report documents in particular how the day after the Shelby County decision, Alabama announced that it would enforce its restrictive voter ID law for the 2014 election cycle. Mississippi, Texas, North Carolina, all of these states also followed suit, taking advantage of the fact that they no longer had to pre-clear any changes to their laws with the federal government. Since Shelby County, and especially relevant today, hundreds of polling places have closed, making voting less accessible for people across a number of demographics. Since the decision, Arizona has 212 fewer polling places. Yes, Arizona, whose ballots we're still waiting on to be counted. Louisiana has 103 fewer polling places. Mississippi has 44 fewer polling places. According to the NAACP, since 2013, jurisdictions formerly covered by the Voting Rights Act closed on average almost 20% more polling places than other jurisdictions in the rest of the country. Additionally, and of course, not surprisingly, many of these polling place closures are disproportionately and predominantly minority areas, which just compounds the difficulties of people of color seeking to vote. But why are these things considered suppressive, right? Why is the absence of a Bull Connor, the absence of an explicitly discriminatory motive, why should we consider that suppression? It's suppression because it raises the cost of participating, right? Many of these things, not only do they raise the cost of participating, they remain legal in many cases. So in effect, a lot of voter suppression is done through legal measures, but it does not change the fact that this mimics the historical efforts to disenfranchise voters. And the COVID-19 pandemic has only exacerbated these burdens on the right to vote. So many of the restrictions that we've talked about, the closing of polling places, and we'll get to voter ID and proof of citizenship requirements and a number of other restrictions. A lot of these restrictions bore fruit in recent primaries and also in the general election. So think back to primaries in April and May where voters waited 4 or 5 and sometimes 6 hours in line to vote in the middle of the pandemic. This also mimics some of the things that we saw in the early days of early voting, where people were also in line for sometimes 9, 10, 11 hours, right? This is not a product of just voters being excited. A lot of this is sort of the culmination of years of closing polling places and making it more difficult to vote. So how did voter suppression used to happen? And why is that relevant now? Well, many of our current voting practices have their basis in laws enacted by states in the late 19th century for the express purpose of disenfranchising African Americans, poor whites, and suppressing the vote. These suppression efforts, many of which were technically facially neutral, many of which were facially neutral, did not technically violate the 14th and 15th Amendments, at least as then interpreted. As I've mentioned, suppression often happens through ostensibly legal regulations, right? So to give you an example of this, take the Mississippi Constitution of 1890, right? In 1890, Mississippi was the first Southern state to call a convention to amend its constitution and change its voter qualifications. And they did so with the express purpose of disenfranchising African Americans. So they did this through a few ways. So they had a very onerous residency rule. They imposed a literacy test. They racially gerrymandered their districts. They instituted a poll tax of $2. And in fact, this poll tax was successful in disenfranchising African-American voters in most of Mississippi's counties. So it was very effective. Mississippi, in changing its constitution, served as a model for other states that were also seeking to disenfranchise African-Americans within their borders. Mississippi was successful because if you look at the effects of all of this, they cut African-American turnout from 30% in 1888 to virtually nothing thereafter, so close to zero. So that's pretty effective. But as I mentioned, and I want to come back to this, many of the changes were legal, right? So they amended their constitution and they imposed these restrictions in part because they did not want the federal government meddling in their affairs. If their constitution was racially restrictive, i.e. Black people can't vote, federal intervention would have been more likely. And so they imposed requirements that were race neutral, even though the effect was to basically freeze African Americans out of Mississippi's political system. It's not until we get to the 1960s that we see significant federal intervention to outlaw some of these practices. But the end result is that efforts to suppress did not disappear, they just merely evolved. So to put this point in context, consider this slide. So the poll tax, which is now illegal, required payment of a fee to vote. So Mississippi had a $2 poll tax. But more important, it exploited wealth distinctions and systemic inequality that disproportionately affected people of color. And so that's why it was effective. It's not, facially discriminatory to say everybody has to pay $2. But when African Americans make such a small amount compared to their white peers, then it has a disproportionate impact. Well, voter ID laws, documentary proof of citizenship requirements to register to vote, and felon disenfranchisement laws replicate these inequalities, even though these laws remain legal. How exactly does the issue surrounding voter ID, proof of citizenship, and felon disenfranchisement mimic the economic and racial issues surrounding the poll tax? Well, historically, supporters of the poll tax presented it as a means for states to raise revenue and to broaden access to the franchise. During the mid to late 18th century, for example, the poll tax did in fact offer a way for non-property owning white men to exercise the right to vote. In contrast, every ex-Confederate state adopted the poll tax during the period known as Restoration, which was from 1890 to 1910, for the explicit purpose of disenfranchising African Americans and in some cases poor whites. Since poll taxes or any other tax as a precondition to voting are now barred by the 14th and 24th Amendments, The state's aim is to find something that can mimic the poll tax by exploiting the same racial and social economic fault lines. But keep in mind the general rule. So we have a general rule we can extrapolate from both the case law and the constitutional amendments. The state may not condition voting on one's ability to pay, right? That is our general rule. The Constitution tells us that it's so, right? The Supreme Court has told us that it is so. But here's the problem. Many modern day voting restrictions exploit a weakness in this general rule, right? So the weakness in the rule is that the rule is often trumped by the state's broad authority to ensure the integrity of their elections, even if the end result is that the state has made it more difficult to vote by adopting laws that replicate the effects of the poll tax. Another thing that the modern voting regulations have in common with the poll tax and other disenfranchising laws is that they do little to further the purported state interest and have their basis in racial discrimination. So states often say that they're passing a regulation for, to ensure the integrity of their elections or to, just fill in the blank. The bottom line is there's no relation. So let's unpack this. Let's look at the effect of the poll tax. So the argument for the poll tax was that it promoted intelligent use of the ballot. The state's justification for the poll tax was that it limited the franchise to those most invested in the political process, as evidenced by their willingness to pay the tax. But if you think about it, this argument is, of course, both over-inclusive and under-inclusive, right? Poor people can be as well-versed in public affairs and intelligently cast a ballot as the rich. Rich people can likewise lack the intelligence necessary to wisely use their ballots. It's pretty clear poll taxes had their foundation in racial discrimination, especially when you look at the data. Southern legislators actually stated that that was the purpose. So to the extent that there was a discriminatory intent requirement, which is not something that the court imposed in 1890, it would have been met, right? The constitutional conventions during that time said that they were trying to disenfranchise Black people. But on top of that, even without those statements, it was clear it had a discriminatory impact. Take a look at these charts. So if you look at Georgia, Georgia had one of the worst poll taxes in the country because it was cumulative, right? So if you didn't pay 1 year, it was compounded with the next year and so on until you paid it. And most people after 1 year couldn't afford to pay it. So if you look at these charts, in 1880, Georgia's turnout was already low, 48.8%. It adopted a poll tax. This dropped their turnout to 37.3% in the 1888 election. As compared to the rest of the South is holding steady. But you can really see the impact of the poll tax when it's broken down by race. So with respect to whites, in 1880 in Georgia, they were at 56%. In 1888, they were at 56%. So a lot of that drop is clearly from African Americans. African Americans were at 39% turnout in 1880. By 1888, it had dropped to 19%. But also compare Georgia to Florida. In Florida, African Americans were still voting at a pretty high rate. Their disenfranchising efforts were a bit different, so it took a little longer. But 88% in 1880, but 64% in 1888. Compare that to Georgia's 19% in 1888. Keep in mind, there's no record of anyone ever being prosecuted for failing to pay a poll tax, right? Most states went out of their way to avoid collecting it. The idea was not to raise money. Instead, it was to exclude people who were deemed politically or racially undesirable from exercising their right to vote. So, let me also give some perspective on the amount. So today you may be like $1 or $2, that's nothing. Well, in the former Confederacy, the per capita income in 1880 was $86, right? In 1900, it was $100. Having to pay a poll tax of $1 or $2 was a very significant haul. Okay. Let's compare this to voter ID laws and proof of citizenship requirements. These requirements condition voting on the ability of one to pay if one has to purchase, but cannot afford the underlying documents to get the ID or to show proof of citizenship, such as birth certificates or naturalization papers. Alternatively, excuse me, states often make it hard to get the proper documentation or ID itself. But states impose these requirements because the Supreme Court has held that the state has broad authority to ensure the integrity of its elections. So legally, states must provide the ID, but not the underlying documents free of charge if a person cannot afford it. So birth certificates can cost anywhere from $10 to $25. And in some places the cost can exceed $40. In comparison, a passport is $110. So if you take a look at the chart on the right, the chart is a few years old. So some states have raised the price of their birth certificates, but it gives you a general sense of the price range. So for example, in Texas, a birth certificate is $23 now instead of $22. Mississippi is $17 instead of $15. In Georgia, though, this one stands out to me. A birth certificate is still $25, but now there's an $8 processing fee. So in effect, the birth certificate is $33 now. For naturalized citizens seeking to show proof of citizenship, but they've misplaced their papers, well, that'll cost you $220. In comparison, the poll tax averaged $10.64 in today's dollars. According to the Brennan Center, approximately 11% of eligible voters lack the required ID because of both cost and inconvenience. To put these numbers in broader perspective, take a look at these two charts. Over 10 million voters in 10 states live more than 10 miles from their nearest ID issuing office that is open more than 2 days a week. Nearly 500,000 eligible voters do not have access to a vehicle and live more than 10 miles from the nearest state ID issuing office that is open more than 2 days a week. Why does this matter, right? Why does it matter that people don't have access, that people cannot afford to get the requisite documentation to get their ID? Why should we care about this today? Because the reality is that it just mimics historical patterns of discrimination. I'll give you a couple examples to make this point. So Dallas County, Alabama, 1965. In 1965, less than 1% of African Americans were registered in this county. And this was so even though African Americans constituted half of the county population. The registration office was open only 2 days a month, and the registrars would arrive late, they would leave early, they would take long lunches. That, of course, made the process of registering to vote difficult, if not impossible. Now compare this to America today. So Georgia, of course, closed DMVs in predominantly minority areas, seeking to make it harder to get the ID that you need to vote. Mississippi, Texas, Alabama have part-time ID issuing offices, also making it difficult to get the ID needed to vote. More than 1 million eligible voters in these states fall below the federal poverty line and live more than 10 miles from their nearest ID issuing office that's open more than 2 days a week. So just so you get some sense of how much of a burden this is. Florida is also guilty of trying to make it more difficult, just like Dallas County, Alabama, right? They significantly cut back early voting days once it proved that these days were, particularly Sunday voting, was used by Black churches to get their membership out to vote. So I want to make one other point on this slide. This is not limited to the South. I know that I've mentioned a lot of Southern states, a lot of states that were covered by Section 5 of the Voting Rights Act, but it's important to understand that this is a nationwide problem. So Wisconsin, for example, the ID issuing office in Sauk City, Wisconsin, is only open the 5th Wednesday of any month. If we were in person, I would tell you guys to raise your hands and tell me how many months have a 5th Wednesday, right? Because obviously not every month has a 5th Wednesday. And the chart in the lower right-hand corner gives you some sense of the impact of these laws. It does not fully explain the numbers, of course, because suppression is systemic. People make a lot of choices that affect their willingness to vote and so on. And suppression also derives from multiple laws and behaviors, but it gives you some sense of the problem, of the scope of the problem. So Hispanic voters, 47% eligible to vote, but unable to vote. 42% of Black voters and 29% of white voters respectively. So not only is the problem systemic, but it also affects demographics beyond people of color. Another example, North Carolina, 1889, right? In North Carolina, in 1889, they passed a voter registration law, which voter registration is something that everybody is familiar with. In most states, you have to register a certain amount of days before you vote, though some states have same-day voter registration, but most of us know voter registration. In North Carolina, the voter registration law required the voter to prove as near as may be, quote, his age, occupation, place of birth, and place of residency by such testimony under oath as may be satisfactory to the registrar. So age, occupation, place of birth, these are all things that we are familiar with, and it doesn't really sound strange to us now, but everything is contextual, right? So Black men born into slavery did not know their age in many cases. They often lived on streets with no names and in houses with no number. So the voter registration law was targeted towards disenfranchising that demographic. So even though voter registration is common today, in 1889, it was a way of disenfranchising African Americans because of this broader context. And you also have to understand what was going on in North Carolina politically at the time. which is why I included this picture of the New York Daily World, right? It was a very contentious political situation that erupted into violence, into something that the press called the Wilmington Insurrection of 1898, in which white supremacists overthrew a duly elected fusion government of whites and blacks in Wilmington, North Carolina. Compare this to North Dakota 2018. North Dakota 2018, they also adopted a pretty restrictive voter ID law, but it doesn't seem restrictive until you consider the broader context. So North Dakota's voter ID law requires that prospective voters show a valid form of identification that provides the person's legal name, current residential street address, and date of birth, right? Seems pretty straightforward. In many states, that would be no problem. But in North Dakota, it is a problem. A large percentage of Native Americans in North Dakota live on reservations with no addresses. So this law actually disenfranchised a huge chunk of that population. As you can see from the photo on your right, tribal leaders had to print IDs in order for individuals who lived on reservations to be able to vote. But many individuals were still disenfranchised ahead of the 2018 elections because of the sheer number of people who needed IDs. Now, I'm not saying that North Dakota will descend into violence like 1889 North Carolina, but there was a very extremely competitive Senate race in North Dakota that prompted these disenfranchising efforts, right? So it really does illustrate how even over a century, the goal of disempowering and disenfranchising minorities is still very present. Another point of comparison between the poll tax and voter ID laws and proof of citizenship requirements is that these requirements also fail to facilitate the purported state interest. Sorry. That's my dog. So the voter ID laws and proof of citizenship requirements also fail to facilitate the purported state interest while disproportionately affecting people of color. So keep in mind that the Supreme Court upholds these laws based on the argument that states can legislate to prevent fraud or the appearance of fraud, even though voter fraud is rare, right? So the Washington Post, in a study conducted by that paper, found 31 credible instances. And when I say instances, I don't mean prosecutions or convictions. I mean just credible allegations of in-person fraud from 2000 to 2014 out of 1 billion votes cast. Similarly, an Arizona State University study found 10 cases nationwide from 2000 to 2012 and 0 successful prosecutions of voter fraud in 5 states where politicians have claimed that there's fraud during the years 2012 to 2014. Despite the lack of hard concrete evidence of voter fraud, allegations of fraud are still common. And it really does undermine trust in the system, and it perversely justifies more restrictive voting measures, which are supposed to be about combating the fraud that doesn't actually exist. So even though in-person voter fraud and illegal voting by non-citizens is negligible, 9 states have passed voter ID laws since 2011, which affect approximately 3.8 million voters. So 12 states have introduced laws requiring birth certificates and other proof of citizenship requirements. 3 passed. I won't say anything about Kansas being part of the 3. But it matters when elected officials insinuate that the system is fraudulent because they can pass laws to back up this assertion, no matter how erroneous, no matter of the fact that it has no basis in reality. And like the poll taxes, many current regulations have their foundations in racial discrimination rather than the actual existence of fraud, right? So the requirement of voter ID clearly has a disparate racial impact. Although 11% of all voters lack the requisite ID, among voters of color, this number is much higher, as you can tell from the chart on the right? There are 1.2 million eligible Black voters and 500,000 eligible Hispanic voters who live more than 10 miles from their nearest ID issuing office that is open more than 2 days a week, which contributes to this disparity in a way that is strangely reminiscent of the shenanigans of registrars in Dallas County, Alabama, who would close early to prevent voter registration. Proof of citizenship requirements likewise have disparate racial impacts. In Arizona's first primary election, for example, after they implemented a proof of citizenship requirement, 75% of new registrants in Arizona's largest county were rejected for failure to provide documentation. In subsequent elections, this number dropped, right? Intense public education, just getting the word out about what was needed. But of course, Hispanics are disproportionately affected by the proof of citizenship requirement in Arizona. Okay, let me say a couple words about felon disenfranchisement, because it also seems to be an exception to the general rule, right? That you cannot condition voting on the ability of one to pay. Yet this idea of requiring people to pay all fines and fees prior to the restoration of their voting rights seems to implicate that general rule. But it's an exception because the person has been convicted of a felony and the state has broad issue over felon disenfranchisement and when those individuals are entitled to get their voting rights back. So one could conceivably serve their prison sentence yet still be disenfranchised because of an inability to pay fines and fees. This has had huge impact, particularly on communities of color. According to the Sentencing Project, individuals who have completed their sentences in the 12 states that continue to disenfranchise people post-release make up 50% of the 6.1 million people disenfranchised because of prior felony convictions. So 50% of that 6.1 million are basically people who cannot pay their fines and fees. In 6 states, mostly in the South, not surprisingly, but also some out West, more than 7% of the adult population is disenfranchised because of felony conviction. Re-enfranchisement has raised some interesting issues, particularly for the current election cycle. So it has really become the latest vehicle in which states have tried to exploit racial and economic fault lines. Let's take Florida's Amendment 4, for example. So Florida's Amendment 4 re-enfranchised most of the state's residents who had felony convictions, but then the state legislature passed and the governor signed a law that required these individuals to pay all fines and fees prior to exercising their right to vote. Note, however, that Florida had made it literally impossible for many individuals to find out how much they owe. Even when individuals with felony convictions could get a copy of their judgment, it did not always identify precisely how much a defendant must pay. So private organizations stepped in to try to pick up some of the slack here, including one that tried to create a database for people to go on so they could figure out how much they owe. But even in the process of creating that database, the organization found out that a lot of counties didn't even digitize this information. So it really seemed that, like the poll tax, the Florida law did not actually mean for fines and fees to be collected, right? That this was just blatantly an attempt to disenfranchise. Another red flag here is that it would take approximately 21 extra employees in the Division of Elections to screen applicants in order to see whether or not their fines and fees have been paid. And the Florida law, of course, provides 0 new employees to perform this function. And so in many ways, the Florida law operated somewhat similar to the Georgia poll tax in the 1880s, right? The poll tax was cumulative indefinitely and it functioned as an effective bar to vote in because after the fine accrued over so many years, no one could pay it. This is a very similar type of wealth-based disenfranchisement effectuated through a maze of statutes and administrative rules and policies that make it very difficult for individuals with felony convictions to actually find out how much they owe. Okay. One last point about felon disenfranchisement. Like voter ID and proof of citizenship requirements, it does very little to further the state's regulatory interests, and it has its basis in racial discrimination, probably even more so than the other two. So the Supreme Court, though, ignores this, and it basically treats the state's ability to disenfranchise felons as plenary, and for the most part unencumbered. So they can do so, and they can pretty much do so freely. And a lot of this is based on notions of the social contract and the fact that, you know, these individuals are perceived to have broken it. But felon disenfranchisement and efforts to prevent re-enfranchisement, at least in the post-Reconstruction era, was really designed to perpetuate the effects of the poll tax, right? They wanted to exploit racial and economic fault lines. And in fact, history bears this out. So for example, although the 13th Amendment barred slavery, states forced Black convicts to work as punishment for crime, which was legal since the 13th Amendment permitted forced labor for duly convicted criminals. From the 1860s until the 1920s, though, Southern states passed laws so that virtually anything an African American did would constitute a crime. So then that they could, you know, arrest them, convict them, lease them out as to individual corporations for manual labor, and the states would get paid for this. And then they would disenfranchise those individuals that survived this horrible situation upon their release. And so it effectively functioned as a pseudo slavery. And the legacy of this convict leasing still lives with us. In many of the states where this practice was popular, African Americans remain disproportionately disenfranchised because of felony conviction. So this is especially true in the South and the West. 13% of African American men cannot vote due to criminal records, a rate which is 7 times the national average. And if you look at this chart, the states that are the worst offenders really stand out. So Alabama, 15% of African Americans, and this is all African Americans, this is not just African American men. Arizona, 11%, Florida, Louisiana. So it's no surprise the states that are on this list. Mississippi, Nevada, Tennessee. So all states in the South and the West mostly, although this is a somewhat universal problem. I don't want to make it seem like the North has been terrific on this issue either. Okay, so what's the common thread here? The common thread is that while the states can make it more difficult to vote through restrictive voter ID laws, through proof of citizenship requirements, or by disenfranchising those who have been convicted of a felony and then making it hard for them to regain their rights, states actually have very few obligations to make voting accessible. And Congress's power to increase those obligations is limited. And efforts to suppress the vote remain common. This is not something that has went away. As John Lewis used to always say, if the right to vote wasn't precious, they wouldn't work so hard to take it from you. Yet we still look for Bull Connor, right? We're still looking for discriminatory intent. We're still looking for actions by horrible people to keep people away from the polls. But many of the restrictions and inconveniences that we deem to be a normal part of voting should violate the Constitution in the same way as using water hoses and dogs to keep someone from going to the registrar. The Supreme Court in Harper versus Virginia State Board of Elections held that the 14th Amendment protects a fundamental right to vote. But more importantly, violation of this right does not require that the disenfranchisement be on the basis of race. As the case law has developed over the last 4 decades, the strict scrutiny standard that the court implied in Harper has evolved to one in which the court weighs the benefits of the law against the burdens on voters. But a lot of voting regulations are burdensome for no good reason. But unfortunately, we don't think about efforts to suppress the vote as a burden on the right to vote in the same way as we think about outright disenfranchisement. If a state closes polling places, for example, which subsequently lead to long lines like we saw on election day and during the primaries and during early voting, we should think about that as voter suppression. And we should think about it as voter suppression that is potentially violative of the right to vote. But the reason we don't usually is because we lack an affirmative vision of the right to vote that our Constitution protects, rather than just what the Constitution prohibits. And it's really this oversight that impacts modern conceptions of voting and representation. The lack of an affirmative vision is why the Supreme Court can require voters to go to the polls in the middle of a global pandemic, even if the fault lies with the state that failed to send these voters their requested absentee ballots. Respecting the right to vote means that we have to stop looking for bad actors and have to start policing bad practices. This does not mean that intent is never relevant. Rather, suppression has evolved in ways we cannot continue to ignore, and suppression should not, intent should not cabin our analysis. Yet beyond a minimal guarantee of a right to vote free from intentional racial discrimination, citizens have to take steps to exercise the right with little aid from the government, even if this means waiting in line for hours. The Supreme Court adheres to this view even when the barriers to voting are the functional equivalent to state-sanctioned disenfranchisement and therefore threaten American democracy. Modern restrictions serve as a reminder of the fallibility of the American project and that democracy is not inevitable or a given. After all, the last time we lived in such a moment where voter suppression and voter disenfranchisement became par for the course, democracy was dead for almost a century. All right, thank you very much. Happy to take your questions.
Great, thank you so much, Professor Tolson. Really excellent and timely talk, and I do have some questions to share. One of the first question is from one of our faculty. The quote, "history is repeating itself" slide suggests reconceptualizing voter suppression, but isn't something much more aggressive required, such as perhaps federal action requiring states to make national voting days official holidays and/or federal action requiring states to have vote by mail?
So an affirmative vision of voting is difficult under our current constitutional scheme. So in terms of the suggested recommendations here, a vote by mail, national election day being a national holiday. Was that part of the question or did I make that up?
Right. Would there be federal actions like
Yeah.
requiring the states to make national voting days official holidays?
Okay.
Or requiring states to have vote by mail?
Okay. So I actually want to take those two examples because I think they're good ones. And so most states already have some provision in place for vote by mail. So I think the suggestion is, could the federal government standardize that to some extent in order to ensure broader enfranchisement? And also ensuring broader enfranchisement by having election day be a national holiday. Maybe for federal elections, right? And so under the elections clause, Congress has power to set time, place, and manner. That authority is initially delegated to the states, but Congress can step in and override state regulations and regulate as it sees fit. So conceivably, those are two things that could be accomplished through federal action under the elections clause, but it wouldn't apply to state elections, right? So if you look at our Constitution, a lot of the provisions that touch on voting operate in that way, right? There's always some gap. Even the right to vote that the Supreme Court interpreted in Harper versus State Board of Elections, because it's judicially interpreted, then the court is free to backtrack, right? The court has determined the existence of the right. The court is free to define the contours of that right. The only thing that will really get us toward an affirmative vision of voting is a constitutional amendment that enshrines the right to vote in the Constitution, right? Then it would be beyond argument that Congress could make election day a national holiday for state and federal elections and local elections. To me, it would also be beyond argument that the Congress could set minimal standards for vote by mail. But under our current constitutional scheme, it is difficult to craft a vision of an affirmative vision of voting, particularly when our constitutional tradition is one in which rights tend to be defined in the negative.
Yeah, well, a related question was the extent to which I think earlier in the presentation, you talked about the distance and the challenges of getting to a voting place. To what extent have has advanced voting and expanded advanced voting and mail-in voting countered some of those concerns? Do you have any sense of whether it's been effective as a response at all to those issues?
So the reason I know it's been somewhat effective is because there have been steps taken to try to make it more difficult. So for example, there was a decision out of, I was just looking at it, the Sixth Circuit, which restored a Michigan ban on free transportation to the polls, right? So when you have laws like that, something's working. And so I do think some states have taken steps to try to counter some of the difficulties people have. So this isn't a 50-state story. Suppression can happen in any of the 50 states, certainly, right? We tend to think of it, voter suppression, voter disenfranchisement, as Southern phenomena in a lot of cases, although people are starting to realize that there are states in the North that can be really bad on this. Like, for example, New York has horrible voting laws. But generally speaking, anytime you see bans on something, you know that people were doing things in order to try to make it easier. Because why on earth would you ban free transportation to the polls, right? That is something that helps people. I mentioned in my presentation how many people don't have transportation. This is clearly something good. So I do think that some states, though, as a counter to that, have tried to take steps to make it easier. And in particular, some states have tried to make voting easier in the midst of this pandemic. So don't read my presentation as an indictment of all 50 states, right? But there are enough states to give you concern. And particularly these are states where they are competitive states, right? Battleground states where the electorate is almost evenly split. And when you have that type of situation, you're likely to have more voter suppression, more voter disenfranchisement, and more people having difficulty enjoying their rights. And so this is another reason why I think constitutional amendment is important in this context, because it would even the playing field, right? You wouldn't have to move to California, which is lovely, by the way, right? But you wouldn't have to move here in order to be able to vote with ease. You should be able to live anywhere and have that option open to you.
Another question from our faculty. I'm wondering whether Professor Tolson would comment on the disenfranchising effects of structural features of our democracy, such as Wyoming's having as many senators as states with large minority populations, such as California, and of course, the Electoral College. I don't know if you can see the questions in the Q&A. You might be able to see them yourself. Should be the top question there.
I don't know. So my opposition to the Electoral College is, I think, rooted more so in sort of intellectual arguments against it. But my opposition to the structure of the Senate is more so like, I live in California. Why do people in Wyoming have the same amount of voice that I do in the Senate? And that's not a good reason. So with respect to the Electoral College, though, so it's a couple things that bother me about the Electoral College. The first is it's really hard to divorce the Electoral College from the fact that some of the founders wanted to get a political benefit from the fact that they own slaves. And so it seems really odd to be a 21st century, quote unquote, democracy, where we're operating within a framework that is a compromise between slave owners and the rest of the nation, first of all. Second of all, the Electoral College is the reason why in 2 of the last presidential cycles, we've had the popular vote loser go on to be president anyway, which is also a problem for a country that holds itself out as a mature democracy. But even more so, the Electoral College has proven to be terrible at mediating the fact that our electorate is polarized. Partisanship and political affiliation and political parties effectively means that the Electoral College does not look like the Electoral College of 1803 when the 12th Amendment was ratified, right? It looks like a tool that partisans use in order to gain some advantage in the context of a presidential election. And a lot of my work tries to recenter, at least to the extent that we want to hold ourselves out as a democracy, we need to recenter it towards the voters. The Electoral College does not facilitate the wishes of the voter. And so either we're a democracy or we're not. If we're going to hold ourselves out as a democracy, then the Electoral College is a structural feature that we should be trying to change because it is very anti-democratic. And I think that's why I have a problem with it. And I mean, I guess the 2 senators per state is also anti-democratic to some extent, but I think it just really pisses me off as a Californian.
Another faculty question. Thanks to my faculty colleagues for following our usual format. It's wonderful. Although Shelby County invalidated the pre-clearance regime of the VRA, Section 2 continues to prohibit laws and practices that have discriminatory effects. Why haven't more Section 2 suits been brought against the suppression methods you identify?
It's really hard to win a Section 2 suit. It's really hard. It's very burdensome. It's very expensive, and courts hate them. And I also hate to be the harbinger of death here, but Section 2 is also facing potential invalidation because it's an effects-based statute and based on a constitutional provision that the court has read to require intent. And so I think I'm hesitant to say bring more Section 2 suits because I kind of feel like the writing's on the wall, which we might see. The court has granted cert in a Section 2 case, a ballot harvesting case out of Arizona that they may actually weigh in. I don't know, but I'm worried. So that's my reluctance to say bring a Section 2 claim, but also just from a practical standpoint, those lawsuits are very difficult to win, and they're very expensive, and they take a long, long time to win. This was the beauty of Section 5, right? No lawsuit was really needed, right? Law is suspended. You have to go to the district court in DC or the Department of Justice to get it pre-cleared. Easy peasy. So Shelby County has really upended the system in a sense, because now we don't have Section 5. Section 5 was also a good deterrent, right? So if states thought that it was possible that their law wouldn't be cleared, so they could appeal it to the district court in DC, or they could just change it and do something else, right? So it was an incentive for courts to be more thoughtful in the impact that their laws had on populations of color, but we don't have that anymore. And so Section 2, yes, it's still there. There has been Section 2 litigation in the wake of Shelby County challenging some of these practices. And in particular, there's been cases challenging voter ID laws on Section 2 grounds. But in large part, this is an uphill battle. A lot of this litigation is not successful.
There are a number of more questions, but it is 5 o'clock. So in respect of your time and everyone's, we'll leave it there. But I hope that if some of my faculty colleagues want to reach out to you with some follow-ups, I hope you can,
Of course.
they can connect that way. Thank you so much, Professor Tolson, for joining us. It's wonderful to see you and to have you with us. Thank you, and be well.
Thank you
We'll
so
talk
much
again
for having
soon.
me. Of course.
Thanks everyone for attending. This concludes the fall plenary lecture. Take care, everyone. Thanks so much.